appeal Brown and Cohort to Scotland.
Lord Reid will explain the decision of the court.
In this country, the prison services make an effort to address the causes of offending behaviour, so that prisoners are less likely to reoffend when they are released. For example, prisoners may be offered courses addressing such matters as the abuse of drugs or alcohol, anger management, and sexual offending, depending on which courses are relevant to their situation. They are generally expected to have successfully completed courses of that kind before they will be placed in less restrictive conditions, for example, in an open prison, and eventually be released on licence. But there can be delays in providing such courses and placements. As in other public services, the available resources are limited. Some years ago, when indefinite sentences for public protection were introduced without adequate preparation, the rehabilitation system was completely overwhelmed. The European Court of Human Rights held that the government was under a duty under the European Convention on Human Rights to provide opportunities for rehabilitation to prisoners serving indefinite sentences for public protection who had served the punishment part of their sentence and were being kept in prison purely for the protection of the public. This court has previously accepted that that is right, and it has applied the same principle to prisoners serving life sentences who have completed the punishment part of their sentences and are being kept in prison for the protection of the public. On the other hand, the European Court has held that the principle does not apply to prisoners serving ordinary sentences, the whole of which have been imposed as a punishment. The question which arises in the present appeal is whether the duty to provide opportunities for rehabilitation applies to prisoners serving what are called extended sentences. These are sentences which have two elements. First, a sentence of imprisonment for the purpose of punishment, called the custodial term, and then a period of release on licence, which is longer than usual, called the extension period, which is imposed for the protection of the public. During that extension period, the former prisoner can be recalled to prison and kept there until the extension period has expired, where that is necessary for the protection of the public. The appellant is a prisoner who was given an extended sentence comprising a custodial term of 7 years and an extension period of 3 years. He was released on licence after serving 2/3 of the custodial term, but was recalled to custody after committing another offence. He then remained in prison until the extension period had expired. He complains that he was not provided with appropriate rehabilitation courses following his recall to prison. In the Court of Session, both the judge who heard the case at first instance in the outer house and the appeal judges in the inner house held that there was no duty to provide rehabilitation courses to prisoners serving extended sentences, because they were not at risk of detention for an unlimited period of time, unlike prisoners serving life sentences. They also held that the appellant had in any event been provided with appropriate courses, but had failed to take advantage of them. The appellant now appeals to the Supreme Court. This court unanimously dismisses his appeal, but in one respect for different reasons from the courts below. The court holds that the duty to provide a real opportunity for rehabilitation does apply to prisoners serving extended sentences if they are kept in prison after their custodial term has expired. The reason why the duty has previously been held to apply to life prisoners and other prisoners serving indefinite sentences, once they have served the punishment part of their sentence, is not that they are at risk of unlimited detention, it is that they are being held in prison solely for the protection of the public, and must demonstrate that they no longer present a serious risk before they will be released. That reasoning also applies to prisoners serving extended sentences, once the custodial term has expired. Although they do not face unlimited detention, they do face detention for an indefinite period, which will only end when either they're considered to be safe to release or the extension period expires. But on the facts of the present case, the appellant was provided with a whole range of appropriate courses and was given opportunities to progress to an open prison and to spend time in the community. The fact that he was not released until the extension period expired was not because of a failure to provide him with these opportunities, but because, despite the opportunities, He was guilty of repeated misconduct in prison, which indicated a continuing risk to the public. Although there were some delays in the provision of some courses, there was not such a serious problem as to meet the high test required by the European Court before there will be held to have been a breach of the duty. The appeal is therefore dismissed.